This is Duke University.
How many people in the crowd are from the law school? Great. Yes. Good showing. How many are from Fuqua? Yes. Pretty good showing. We're gonna have a battle later on. So I'm trusting the Fuqua kids just because you're a little older and wiser. You can take on the larger numbers. How many are from Pratt? Anybody? All right, we got a few. How many undergrads? Anyone? Great. Anyone I missed? Med school, PhDs. Where are you from? Okay, great. Anybody else? Someone else? Raise your hand.
Local entrepreneur.
Great. Glad to have you.
Nicholas School.
Okay, excellent. Nicholas School is represented by one right now. I'm taking a class over there. All right, so last question. Well, two questions. How many people here is this your first time coming to an entrepreneurship-related event at Duke? Okay, not bad. Glad to see it. All right, does everyone, so there are some handouts on your seats, or should have been. If you don't have any, raise your hands so Howie can bring you some. There you go, Howie, you got a couple here. Just keep your hands up for a second. Yep. Also, there's some feedback forms, and I'll remind you of this at the end, but we would like you to fill out the feedback forms at the end of the event and just leave them in your seats. Please do that. All right, so in business school, they teach us to set an agenda before we start any event. So the agenda for tonight, first, before the main event, which is obviously Bill talking about kill or be killed, which is really exciting. I'm excited to hear about that one. But before that, I'm going to just give you a little background on D's and what it's about. And we're going to also have Steve come up, who's one of the chairs for the Duke Startup Challenge. And I'm sure a lot of you are interested in competing in that this year. He's going to come up and tell us a little bit about Duke Startup Challenge. Then we'll have Bill speak. Pardon me, Professor Brown, and then we will have a couple of students do elevator pitches for their business ideas. And so, just giving you a warning, if anyone out in the crowd wants to do an elevator pitch for your business idea to potentially attract team members for the Duke Startup Challenge, just be thinking about that. Low pressure environment, nobody's going to judge you, nobody's going to boo you if you do a bad job, but it is a good opportunity to maybe attract some teammates. This is a smart crowd here, I believe, so it should be good. So anyway, just to quickly introduce these, this is a joint effort by several groups. One is the Entrepreneurship and Venture Capital Club over at Fuqua, Duke Startup Challenge, which is the premier entrepreneurship competition here on campus. We've got DuHatch Student Business Incubator, Fuqua Center for Entrepreneurship and Innovation, and the Duke Center for Entrepreneurship and Research Commercialization. So all these groups have come together to put on a pretty amazing speaker series. And in the second year now, it's a pretty cool series. Hope you guys enjoy it. So I wanted to quickly thank some of our sponsors. So you see we've got some pretty high-profile sponsors here. InterSouth Partners, just going to give you a little background on them so that in case you guys don't know who these people are. InterSouth Partners is the largest venture capital firm in the state with about $700 million under management. And we've got two local law firms that are pretty much the tops in terms of representing startups, Hutchison and Wyrick Robbins. We've also got iContact helping us with email marketing, HPG, which is an accounting firm that helps startups, Palo Alto Software, which has donated copies of Business Plan Pro to any Duke student thinking about starting a company. So keep that in mind. I think Howie might be the person to contact if you are interested. His name is Howie Reed, R-H-E-E. And then Square One Bank, which is a national venture bank based in North Carolina. And then, of course, I want to give special thanks to Professor Brown for helping us set this up and for being the main draw here. So I'm about to get off stage. I know you guys can't wait for that. So just real quickly, there's several courses at Duke in entrepreneurship. This series was designed to sort of complement those courses at all the various schools. So the series is designed, as you can see, we've already had one of the talks, and actually we've also had the Office of Licensing and Venture Day. And today is the third event, Entrepreneurial Law 101. But the series is sort of set up to take students through the process of business planning and ultimately venture creation. And it's also sort of just meant to give you the structural view of the key entrepreneurial concepts throughout the year. Timing-wise, it's also designed to sort of match up with Duke Startup Challenge in a few different ways. And that's a good segue to bring Steve up here to talk about the Duke Startup Challenge and sort of hit on timing for stuff with that. So come on up, Steve. No, I think you need to switch your slide.
No, that makes sense.
He needs to switch to the slideshow.
Oh.
Yes, my name is Steve Powell. I'm a second year review student, and I am one of the co-presidents of the Youth Start Challenge. So just by a show of hands, a lot of these folks are actually new. I didn't see you guys at previous these events. So how many people have never heard of the Youth Start Challenge? A couple folks. How many people have heard of it, but you don't know what it is? Okay, so I think you combine those two groups. It's actually quite a few folks that don't know what the Duke Startup Challenge is. So, the Duke Startup Challenge is, as Tommy mentioned, it's the premier entrepreneurship competition on campus. It's a student-run organization where students are competing for seed capital for their business idea. It runs the course of the year, and the idea is that students from all over campus, whether you're from the law school or from business school or any of the undergrad colleges, everybody is eligible to compete, and you're competing for prizes up to $25,000. So over the course of last year, we gave away over $45,000 in caps and prizes, and this is actually the 11th year that the competition has been running. So it's been around for quite a while. Has quite a heritage. We have, I think, easily over 1,000 competitors have come through, over 400 teams, and I think over the last 11 years we've given away over $500,000. So we've been doing it for quite a while, and it's a good opportunity really for folks for you guys to take a lot of this knowledge that you'll be learning through D's about the entrepreneurial process and to really put it into practice. And so essentially what it is, it's a series of competitions that we have throughout the year. There's two main competitions. The first is the elevator pitch competition, which is coming up in November. And the other major event is an executive summary contest / finals event. And I'll go into the elevator pitch competition in a little bit more detail, but basically what that is, if you have an idea for a business, you basically give a 60 to 120 second pitch, basically a 2-minute pitch for your idea. That goes before a panel of judges, and then we kind of choose the best pitch, and I'll talk about what the week looks like. But you can win money and prizes at that event for your idea. And then in January, what we do is executive summaries are due for your business idea. You basically submit that. Those also go before a panel of judges. The judges are generally venture capitalists, lawyers, and people from the industry. The top executive summaries that are selected in that advance to the finals, and then in the finals is where you compete for, like I said, that $25,000 prize. If you're competing in the competition, there's actually several different tracks that you can compete in. Hopefully, you guys can see this, but there's some functional tracks. So IT and media. Energy and environment, social enterprise, products and services, healthcare and life sciences. These are sort of like functional focus areas that you guys might have startup ideas around. And then we also have some special interest groups like undergraduate and women. So you can compete in those, and you can compete in these. You can actually compete in multiple tracks. But the idea is that the best idea from each of these is going to advance to the final. So here's what the elevator pitch competition is going to look like this year, just to give you a sense for it. It's a week-long event. During Entrepreneurship Week, it's November 16th to November 20th. Essentially what we do is from Monday to Thursday, there's essentially like these semi-finals, you can think of them. Each of the tracks that I just talked about, like IT and media, undergraduate, etc., will have a competition during the week. And then the winners from each of those will advance to the finals on Friday. Friday it's going to be at people, but each of these will have a speaker, and also we're bringing in a high-profile speaker on for the finals event. It's actually Bill Morris, who's the co-founder of Google Ventures. It's the venture capital arm of Google. So it should be a good event this year, but you don't have to compete in the elevator pitch competition to compete in the kind of main executive summary and finals contest. So just so you know. So and you also don't have to compete to participate. I'll talk about that in a second. So there's two ways if you're interested in getting involved. So obviously the first one is to actually compete in the competition. So if you're interested in doing that, we're holding a kickoff event and a match day, match night. I'll talk about this in a little bit more detail, but it's basically a way for if you, Tommy was talking about this earlier, if you are interested in joining a startup but you don't have an idea, you can find a team that, or a person that has an idea that's looking for a team, or if you have an idea and you're looking for a team, this is a way for you to find a team. So we're going to be having an event this coming Thursday on the D schedule, but it'll be over at the business school in McClendon Auditorium. So that's one way to get involved. Another way is actually to help organize the competition. So, as I was saying before, the entire competition is student-run. So everything from raising the money, like raising the prizes, to executing all of the events is all done by students. And we actually have a diverse team of folks from FUCA, folks from undergraduate school, med school, the Nicholas program. So we have folks from all around campus, and we actually love to get a few law students on board to help us organize the competition. But probably the best thing to do is just go on the website to look at some of the opportunities that we have on the organizing committee. But we're always looking for folks that are interested in just getting involved on campus. Okay? So I think it's a good way to sort of broaden your network on campus. It's also a good way to broaden your network off campus too, because there's opportunities to network with venture capitalists and the law firms in the area. Okay? And the applications for that are due next week. Now, one thing I didn't mention is that you can actually do both as well. So you don't just have to compete or just help organize. You can actually help do both. One of the co-presidents this year actually both competed last year in the finals, and he was part of the organizing committee. So next week, if you're interested, so Thursday from 7 to 9, we're going to be holding what we're calling kickoff and match night event. So similar to what you'll be hearing a little bit later after this event, folks will be coming up. It'll be pretty informal, giving pitches for their ideas. If something resonates with you, you might be interested in it. What we'll be doing is after all the pitches happen, probably 10 or 15 pitches, we'll be having just a networking night afterwards where you can go up, meet that entrepreneur, for the person that has the idea, and see if it makes sense to join their team and help compete with them in the competition. So. We'll be doing that this next week. It's a good opportunity, and it's also just a good opportunity just to network with other folks that have a similar interest. Okay, so look out for that. And then if you want more information about the competition, here's the website. It's www.dukestartupchallenge.org. It's probably on some of the handouts you guys already have, but more information about the competition and obviously our upcoming events are up there, and join the mailing list as well. So you can keep in touch with all the events.
There you go. Nope. I thought that's what he ended on. Yeah, that's what he ended on.
Sorry about that, guys. You would think that with all the business experience that you're
Okay, so I usually have a pretty good memory, but Professor Brown's done a lot, so I had to use some notes here. I'm not going to touch on everything he did, and I hope you don't mind. There's a lot.
You hope I don't either.
There's a lot to say here. So just Professor Brown, just briefly, his background, he got a BA in political science and biology from MIT, then came here to Duke Law School. I'm not sure if I'm allowed to say what year, but after he graduated here, he's not really that old. He was actually on the Duke Law Journal here on the editorial board. Graduated, went to New York, and practiced law, ultimately became a partner at Sidley Austin, which is a pretty prestigious law firm for those who aren't from the law school. Went from there to Goldman Sachs and actually helped to grow a trading platform for foreign exchange, which is a pretty new, or probably absolutely new product at that point. Then was stolen away by AIG International, and then ultimately, again, by Morgan Stanley. Then Professor Brown came here to Duke Law, and he teaches business law, business planning, capital markets, and corporate finance courses here, and also just does a lot of mentorship for a lot of students. He's also currently co-founder of Palmer Labs and 8 Rivers Capital, which are both focused on financing and commercializing biomedical devices, traditional energy, alternative energy, and telecom and automotive technologies. So he's a very entrepreneurial guy and has done some pretty amazing things in finance and law. So I'm sure that we've got some pretty interesting things to look forward to here. Without further ado, I'd like to invite you up to talk with us.
Thank you so much. Thank you, everyone. You know, these guys asked me to put a title on this, and I was trying, you know, they gave Entrepreneurship Law 101 as a starter, and I said, oh, no, it's got to be something more than that. And so I just decided, well, if you can have a little blood in it, you know, that's why I came up with Kill or Be Killed. But then after hearing you guys, I think I maybe should have called it Killer D's. But that's only for you Saturday Night Live aficionados. So you know, when I was in law school, I mean, I went to law school really just to, in some respects, because I was interested in being analytical, learning how to think differently. My original thought was that I would go home to the mountains of North Carolina and practice law with my dad. I did that for a summer and decided, well, that's not it for me. And it had nothing to do with my dad, it just had everything to do with the type of law that he practiced. So I ended up going to New York City practicing law. I did project finance, equipment finance, and did LBOs. I did graduate from the law school in 1980. I did graduate from MIT in 1977. So you figure out the years. But I'm now on my 3rd and 4th career. I've had a great time. It's really sort of fascinating to grow businesses. And this was not something I really learned or knew that I could do until I hit Goldman Sachs. And I'll tell you how it happened. I was hired at Goldman in part to help structure financial product. I was hired into the J. division, currency and commodity division. They were building their GSCI index at the time, the Goldman Sachs Commodity Index. They needed someone who knew the legal side of things and who also had a quantitative background, so I was brought in to work on structure. And pretty quickly, they asked me to cover an account, just call them up on the phone every morning and cover the account. And I said, okay, and I just, part of my reaction was, well, what do I say? And I remember the first day that someone says, well, do you think the yen's going up or down? And I just clicked out the phone and said, they want to know if it's going up or down. And I said, what do I tell them? He said, whatever. But what if I'm wrong? Now, keep in mind, I was a lawyer for 9 years. You're not wrong, if you're a lawyer. And so he said, tell them it's going up. It's going up. And that relationship with that client, it ended up becoming one of the biggest accounts that Goldman Sachs had. And my boss called me into his office and he said, Bill, forget all this structuring crap. I want you to go out, I want you and Carolyn to go out and build a business. And we have not gone after asset manager business in the foreign exchange world. We've only gone after corporations, helping the corporations hedge their cash flows and their foreign exposure risk and the like. So I would like to build up an asset manager business. And I looked at Carolyn and I said, Carolyn, I'll tell you what, I'll make you a deal. I take Boston, you can have the rest of the world. And at the time, I thought I was doing something because I was doing something with which I would have a level of familiarity because I knew the Boston market. I'd gone to school there, and in about a year and a half, that same boss called me in and said, Bill, great job. Boston looks fantastic. Give all your accounts away. Do it again. And I go, what? I mean, I own Boston. I can walk in any door up there, and I've built my business. I can walk in any door. He said, exactly. You can do it again. I thought he pulled the rug out from under me. And in some respects, this is the sort of phenomenon that a lot of people hear when they hear failure. Think about it. My boss engineered failure for me. Instant failure. I've gone from being up here all the way back to zero in a heartbeat. And I had to build up a business. I did it again. He said, great, Bill. This time, give away all your accounts, move to London, do it again. And I did it again, and again. And what you start to learn is, that you become pretty or needlessly focused on retaining the known and not focused on embracing the unknown. And that's what entrepreneurship is really all about. It's letting go of the known, and it's embracing the possibilities of what could be. About 2 years ago, one of my best friends from MIT and I, he's sitting back there, Miles Palmer, he's the guy in the white shirt there with the red tie. He and I were walking down the streets of New York, and I was still at Morgan Stanley. And I had a great job. I was running, co-heading a global business, and he made some sort of technological comment. And I said, Miles, you can do that. We could dramatically change a particular industry as we know it, and dramatically change. And that's where the conversation started. And Miles at that point, Miles had at one point in his career been selected to be an astronaut in the Air Force. He worked at SAIC for 22 years. He did defense work. He's designed and flown unmanned aerial vehicles. He's designed and built rocket systems. He's designed and built energy systems. He got the first ever Department of Defense award for converting algae to jet fuel. He's a brilliant guy. He's the smartest guy I know. And so we decided, listen, if we don't do it now, we'll never ever do it. And so to his credit, he decided also to embrace the unknown. And he'd always wanted to put together a business that would allow his ideas to be commercialized. Because if you think about it, where he was in the world, he designed things for the armed services, and sometimes they used them, sometimes they didn't, but they never ever saw commercial use. And so we got together. We've had a fun time in the last year and a half. We've got a number of technologies that we're working on. And the dean came up to me at Duke Law, and he says, hey, Bill, I know you got this VC thing that you're doing. Why don't you come down here and teach? You can run that business from anywhere. Come down here and teach. Well, financially, it was the best thing that ever happened to me. Not because professors make anything, but because, in effect, he forced me to sell my apartments in New York City before they crashed. So it's been a blessing. It's been a blessing in all sorts of ways, and so we're doing a lot of fun things. Some of the stuff here that in putting together this piece for you, I came across this about a year ago. The years 1929 to 1941 were, in the aggregate, the most technologically progressive of any comparable period in U.S. economic history. Alexander Field in the American Economic Review, no slouch journal. Think about it. Think where we are right now. Think what was happening in the 30s. Think what we've just been through right now. We've just been through a situation where it was easy to know what job you were going to do. If you really wanted to make a lot of money, you went to Wall Street, you punched your ticket, you went to a Wall Street law firm, you went to a Wall Street investment bank, whatever it was, you knew the path to making money. In fact, Wall Street sucked away some of the best talent that this country had to offer. It sucked it away. And it sucked it out of the other, away from some of the other sectors of the economy that needed productivity, that needed innovation. In fact, you could even say that we may have just gone through a period where we are innovation starved, where the things that we really focused on was creating financial paper, creating CDOs, various flavors of swaps and the like. I won't give you the whole litany of Elizabeth. And in fact, I personally think that for that reason, because we've been innovation starved, intellectually starved from having creative minds focusing on innovation, I think we're facing one of the golden ages of American innovation. And the one thing I will urge you is to think of, everyone who comes to school these days tends to think about it, how do I get a job? I want a job. Yet we as universities and you, many students, are not set up to think about, I want an opportunity. Because an opportunity may be a job, it may be starting up a company. But everyone in this room, because you're here, the startup challenge, everything that these guys are doing at Fuqua, everything Howie's doing, is helping you find something that will be other than a job. But at least it will be a great opportunity. Okay, startup starts with an idea. I created two characters here, Flo and Buzz. They're having lunch at the Bryan Center one day. Flo was talking about the work that she was doing at Pratt. She was working on various membrane technologies. She was putting together a device that would act as a small dialysis machine, and the ultimate goal would be to implant that small dialysis unit in the human body, and the dialysis would treat the blood, it would take the impurities out of the blood, and it would dump them into the urine, and dialysis and kidney treatment would change. Great thing. That's all the lab is focused on. It's great technology. Now this is all made up stuff. Maybe it's not made up. In connection with the work that Flo was doing, though, she had amassed a huge amount of knowledge about membranes. Some of it she pulled in from the lab. Some of it had sparked her interest in doing outside reading. She knew more about membranes than anyone else around. Buzz, on the other hand, apologize for the names, but had always been interested in electricity. High school, he won a major science prize for the work that he'd done on creating a nanopolymer battery. After entering Duke, he continued to read and think about battery. Buzz was good. He's good. As lunch progressed, Buzz and Flo developed an idea for a new battery technology. Okay. Stop. Is there an issue here? There is an issue here. Flo is working for a Duke lab. She's working for a Duke lab. She's probably an employee. I'm sure she's an employee for a Duke lab, unless she's doing this as part of some sort of a commitment for credit or some sort of study course. But let's look at what the Duke website says. The creation of knowledge in the service of society is at the core of the Duke mission. When new inventions and patentable technology arise during the course of ongoing university research activities, researchers have a responsibility to disclose these things to the office. Duke's policy on inventions in Appendix P, which goes on forever, and we'll talk about Appendix P, has been written to assure that inventions resulting from Duke research are utilized in a manner consistent with university policies. Policies written to facilitate and encourage patent protection. I don't think so, but because and Duke's no different from a lot of places. What happens here in a lot of places is that people hide their technology for fear. They're really great technology. Miles and I have gotten calls from some of our colleagues at MIT, former colleagues at MIT, who say, "Hey, we got this neat technology, but we're not showing it to our university because it's too good." You know? So, Appendix P. Let's do an appendectomy here. University employees who, during the course of their associations with the inventive device, whether or not the university time or facilities, shall cooperate with the university in defining the rights to such inventions by promptly reporting it to the university. I mean, even if you did it fully on your own time, there's no property use, they want you to tell them what you just did. That's a really bad thing. It's really bad for two reasons. It's going to force, if Flo followed this, it's going to force her to breach her obligations to Buzz, her co-inventor. Buzz had nothing to do with that lab. Nothing. And whatever invention they just created together, the two of them, according to this policy, she is either going to get into a little trouble with Duke or a lot of trouble with Buzz if Buzz wants to be nasty. And she's going to put, in fact, she'll put Duke into a position where Duke ends up dealing with this in a way. I mean, Duke could actually expose itself to liability. So, you know, I read this provision here and I just think, my heavens, what are people thinking about? So, because it says it though, your solution is whatever you do, act on advice of counsel. Listen, I don't like it. I don't think it makes sense. I don't like it. But just because you don't like it doesn't mean that you don't have to deal with it. And so therefore, the best way to deal with it is, especially for something like this, you really need to get something, piece of paper you can put in your file, you know, from one of these law firms that we saw up front, or some other law firm that says, you know something, we've examined the policy, there are two conflicts here, but our recommendation is that, what has to happen here is that the patent application has to be filed, a provisional patent application, and then you notify Duke. You know, protect the IP first, take care of your obligations. That's what I would imagine. I'm not giving you advice on this, but I would imagine that the advice that you would get from your law firm would say something like that. The point here is the way I set this up, I intentionally set up the conflict here, and it's a really bad, it puts you into a tough situation. Your only way of dealing with this is just go talk to a lawyer, and you know something? That little piece of paper, the fact that you actually did the due diligence on that, the fact that you actually went and consulted on that is going to protect you. Okay? Okay, Appendix P goes on. And it goes on a lot more than this. A here says, when the invention, okay, it talks about inventions resulting from research wholly on their own time without the use of, shall be considered the property of the inventor. It is recognized that when it's within the specific subject area of the inventor's current and ongoing research activities, flow, right? Disputes may develop concerning whether it was conducted by university holding on their own time without the use of university funds, blah, 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 blah. Well, you got to provide a notice and stuff like this. Okay, fine. That's, your lawyer's going to look at that. Then your lawyer will look at this. Inventions resulting from research or other work conducted by university employees wholly on their own time, but involving some, but not significant use of university funds or facilities. Well, we're going to have a conversation. And by the way, the conversation is going to cost you, as you'll soon see. And finally, this is what the IP policy is designed to cover. You know, you're working in the lab, you're working on university-sponsored research, you're using all the facilities. Yes, that belongs to the university. No doubt about it. Okay? What happens to the money? If you fall in the first category, it's on your own time, doesn't involve the university, it's all your own money. Second, if you use a little bit of resources, I mean, what do we mean, a little bit of resources? Were you sitting on your lab stool reading some outside books? Were you going onto the library website doing research? Were you talking to other faculty members? I don't know what, you know. Somehow you might have been using resources. In that particular case, Duke says, fine, we're going to tax you on 10% of the gross. 10% of the gross. And they don't even pay anything to develop the patent. They don't pay, so it's not 10% of the net, by the way, it's 10% of the gross. And so, again, talk to your lawyer. Your lawyer may say, what's gross may be excessive on its face. Again, you should be represented by counsel. The other one, in the regular world, here's what it ends up being. Anything from 0 to 500,000 that you get out of it, you get to keep 50%. Then the rest of it's how the university sort of fights over the rest of the pie. For the 500,000 to 2 million, you get to keep 33 1/3 of that. And for anything over 2 million, you get to keep 25% of that. Now, by the way, they get to keep all this stuff, but you've got to keep in mind too, is that even if you're doing this in connection with your own lab, there is no requirement that they actively seek to commercialize your technology. You may have the killer battery. You may have the killer battery. and there may be conflicts that exist in the department or whatever that don't want that killer battery to get out there. Maybe it conflicts with some sort of research that's being done, and maybe it just doesn't get commercialized, whatever, you got to at least consider it. Again, I'm trying to show you the situations where getting lawyers involved. Back to our story. Okay, they didn't sit there at Bryan Center and have any interest in getting out there and sort of, thinking about stealing technology that was being done in flows. They were just simply having just an innocent conversation, comparing notes. I mean, it's the sort of conversations people have. This is the way inventions happen. And Buzz says, I know how to put a very large charge in a battery. Flo says, I know how to create a membrane that can be very precisely controlled. I know how we can turn on and off that membrane, switch it very quickly and easily. I know how we can, we do our calculation. This battery can, for a 200-pound battery, can propel a 2-ton vehicle 500 miles without recharging. And when you do need to recharge it, it'll recharge in 5 minutes. Whoa. That's a change the world technology. That's a change the world technology. The whole world is different if that technology existed. If Buzz and Flo developed that, the whole world's different. What's different? Gasoline engines go away. I mean, think how long, if you can refuel with electricity in 5 minutes, it takes 5 minutes to refuel with gasoline. So refueling is, price of oil would plummet. Major oil companies would go bankrupt. Companies focused on production of electricity would be the big winners. It's big stuff. And I hope, I pray that people in this room have that technology somewhere in their head. Our future depends on people like you having technologies like this that will change our world. Now, what do? First rule, don't talk to anyone who's not obligated to keep a secret. Right? Keeping this a secret, because especially we're going down the road of IP, intellectual property, protection here. Because if you were able to sketch this out in some sort of napkin and someone got that napkin, they would have your idea. They were the first, if they could take that napkin and go put a patent together and beat you to the patent office, they would own that idea. Billions of dollars because you didn't protect your secret. Lawyers, where do you go? Well, generally, lawyers are obligated to keep things confidential. And, and in fact, I have to say, in all my experience in practicing law, I think lawyers, they can do some things, they can sort of like weasel around a bit or bend things a bit, but I think they're really good generally on confidentiality. And not just generally, I think almost without exception. I've never felt in all my years that a lawyer has breached their obligation of confidentiality, ever. I might distrust them because they took advantage of me in a deal, or I might feel that they were being overly stubborn, they were asking for things that their clients didn't. A lot of things, but I never ever felt that they breached their obligation of confidentiality. Confidentiality agreements is one thing, but I'll tell you, they're worth the paper they're written on and no more. Because if you and I signed a confidentiality agreement and I'm not to be trusted, and I go out and blab your idea, it's out there. It's done, dusted. There's no way you can put that genie back in the bottle. No way you can put it back in the bottle. I don't care what your confidentiality agreement looks like, there's no way to put it back in the bottle. So let's revise our first rule. Don't talk to anyone you don't trust, and make sure they're legally obligated to keep a secret. Now, I like confidentiality agreements only if I can really trust someone. And the reason confidentiality agreements are important in that case is that it just reminds them that what I'm getting ready to tell you now, I'm really serious. It's between us. Okay? And furthermore, I would even say this. Second rule, protect the intellectual property, and it falls into this. We don't want anyone else copying our battery technology. This invention, if it works, is worth billions. Okay? Now, because of this, you want to adopt the military approach to confidentiality. Need to know. I don't care if you trust somebody. I'm sure you're excited about this technology that you've developed. But if someone doesn't need to know, don't tell them. Don't put yourself in harm's way. Don't even allow the potential of an accident to happen. No matter if you trust them, no matter if you respect them, no matter if there's a confidentiality agreement, no matter if they're your lawyer, whatever. If they don't need to know it, don't tell them. Now, there are different ways, various types of protection for intellectual property. Keep it secret. The most famous thing is the Coca-Cola formula. You know, it's secret, it's kept in the vault. But if someone just posted the Coca-Cola formula, typed it out on the web, it's gone forever. It's no longer secret. All that has to happen, that secret just has to be broken. Trademark, this is a minor thing here for some things. It's about your image, about your branding. In some respects, it's important. iPod. If Apple didn't protect the trademark iPod, everyone could create something called an iPod. So it's an important thing. It's pretty narrow, but it goes to your image. Copyright. Written and recorded material, also software. Patents, inventions and processes, including software, and we'll come back to some of these. Patents. The requirements of patents. And by the way, for the Startup Challenge, let me just say this, for the Startup Challenge and for the elevator pitch, you're going to face, some of you who will have a product that you think is patentable, you can probably not have to reveal the secret sauce in connection with your elevator pitch. But if you have any doubt about your secret sauce for an elevator pitch, you do have enough time to file a provisional patent and get into the regular competition later on. That's really what you want to do. But we'll talk a little bit more about that later. But what do you need to get a patent? Oh, the other thing too is that a lot of you who will give elevator, they'll not be about anything patentable. It'll be just about an idea of how you can do something and put together a really neat business. Think of the number of business. Do you realize that before Amazon, there was a website called books.com? Failed. It had the prime territory. It had the prime territory. It failed. Someone else had the idea. Amazon just executed it better. So a lot of times, the real idea is execution, not anything that's patentable. Okay, what are the requirements of patent? It's got to be novel. Now here's where you get stuck up a little bit. One of the things about being novel, it can't be known. In the United States, under the United States patent law, technically, your invention can be known for 12 months before you file your patent and sort of grandfathered in, sort of brought in. In Europe, that's not the case. If it gets out before the patent application, it's no longer novel, and you cannot patent it in Europe. Okay? But as I said up there, there's a grace period of 6 to 12 months in some countries, including the US, but there's no grace period in Europe. Once you file it, you need to do a prior art search, or you need to find, well, what else is out there? I need to make sure this thing is novel. But even so, you're not going to get any assurance it's novel, and we'll see why in a moment, because there's a whole group of patents out there that are going to be kept confidential and that you won't be able to pull up on a search until they actually become public. So even though, as far as revealed patents, you'll know that it's novel, you still have to wait a period of time before you really know you're out of the woods. It's got to be not obvious. It can't be, it's got to be invented. The standard is a sufficiently skilled person who had knowledge of the prior art would not have come up with it. You can't say, oh, well, I'm going to patent a cloth thing to go on the microphone instead of a foam thing to go on. Yeah, that's obvious, So, utility's got to be useful in work. This is where they get rid of anything for perpetual motion machines. We know that that's not going to work. Industrial, it's got to be used in some form of industry. Things that can be patented generally are processes, machines, manufacturers, and compositions of matters. You can patent chemicals, you can patent widgets, You can patent processes. Most of these are easier to figure out. However, the interesting boundaries exist in three areas. Computer programs. It used to be that you couldn't patent computer programs. And there's a case that I'm mentioning right here that maybe will pull back a little bit on the computer program patenting. Biotech, the genetically modified things, there's a bunch of, it's easy to patent plants because there was specific legislation in the 30s, starting in 1930, that allowed you to patent plants. So plants have better protection than other types of organisms. You can't patent a human being. But certain types of stem cells have been patented. So that's a muddy area. And business processes, you could have, I have a way of making things better, in effect. But here's this interesting case before the Supreme Court right now. It's being considered. It's called Bilski versus Dahl. And essentially, what these guys had was a commodity hedging strategy. It didn't require, in order to execute the strategy, you didn't have to have a computer. You didn't have to have a spreadsheet. You didn't have to write it down. It was just, we could, you and I, if you looked at what this thing was, at some point you just put this thing into the web and look at what this thing, you just go, duh. So just watch this space, because what's going to happen is they're saying that this was too abstract. Well, as soon as they start cutting back on this, which I think most people think they're going to draw a line here. They're going to start eating into business processes and some computer programs. So keep it, duration patent 20 years. Only the inventors can file, but they can be forced to pass to assign it. This comes from the World Intellectual Property Organization. I just had to say this thing again because it's so important. Can I discuss the details of my invention with a potential investor before filing a patent application? And it basically goes say no. That's all that says no in a lot of words. If I can make anything clear to people today, is it's a secret. Don't talk about it until you've got your idea on file, and even then, need to know. Keep it confidential as long as possible, only revealing information to help raise money, and even then, only under a non-disclosure agreement with a trusted investor. Until you've got your patent filing done, don't do idea competitions, elevator pitch competitions. Think of these purely as opportunities for fundraising. If it's really your battery, you got to think about what you're doing. You might do it in a broad way, but I'm telling you, you don't want to throw away, I know it's fun, but you don't want to throw away $1 billion idea because you reveal too much. You might be able to do it, but you got to think really hard about your cost benefit, especially if you've got $1 billion idea. Most of your elevator pitch competitions, most of this other stuff is not going to be a patent issue. It's going to be, I can do Amazon better than Amazon, or it's those sorts of things. It's more of something else, but patent. And this is something Miles and I and our team have really been heavily focused on, and we've seen so many situations. Oops, I guess I shook it into. All right. We've seen so many situations where this has been, has really made us nervous. And so you're hearing the voice of experience here. I've grown, I think both of us have grown more paranoid the longer, we thought that, as long as we filed a patent, we could talk to people, and then all of a sudden you start realizing how this can get you into trouble. So we are really careful. Recommended process, though. You can do this really fast. You can put yourself in a much better situation. And if you did have something patentable, I think you owe it to yourself to get a patent on file. You could do this in a week or two, and then put yourself in a position so that you can talk in the generalities in an elevator pitch competition and still feel 100% protected. Just talk to your patent counsel, but you need to find a patent counsel. File a provisional patent, which will be kept confidential by the U.S. Patent and Trademark Office. At this point, patent's pending. See the little things, patent pending? That's when it's patent pending. It's not a patent, though, until it's granted status by the USPTO. Only talk to people you trust. Then what ends up happening is over the next year you make amendments to your provisional patent. You sort of refine it. You put your stick in the sand, but you refine it. Then you file a full U.S. and foreign patent before 1 year lapses. When you file your full patent, that full patent relates back to the date of your original filing of your provisional patent. So your provisional patent can be pretty bare bones in many respects. If foreign patents are filed, the confidentiality of the U.S. patent then is lifted 18 months after it's filed. So now you see, and people generally, things become public after 18 months because people want to take their technology abroad. Thus, the information in the U.S. patent will be confidential. So, back to our theme. Flow and Buzz have 3 basic questions. What should they do with Flow's lab and Duke University? What are the general parameters of putting their company together? If they need money? So, what do they do about it? They really need legal advice. Why? On the first one, you don't want to run afoul of Duke. Second, because it's often done improperly. And third, because, especially on this one, if you do it improperly, it's really expensive, and we'll see why. Potential advisors. Seek out the law school. Clinics, professors, students. I mean, each one of these guys has the benefit of being cheap, but, you know, they do come with issues. First of all, you get what you pay for a lot of times. Sorry. Many do not deal with these issues regularly. Students are not licensed practice law. You will compromise your students if they're really giving you legal advice, but you can have these sort of informal conversations with them at some point. But you really need a lawyer to provide you with a formal record advice, especially in this Duke matter. And you won't get that from students or professors. I mean, a professor's not going to write you an opinion to put in your file. That said, a clinical program would be the exception, and this is something we're working on. In fact, I'm having a meeting tomorrow morning at 8:30 with Barry Myers from Pratt and Andrew Foster, who runs all the legal programs here on this very topic. So I would love to get a clinical program in place to help provide legal advice into the university environment about entrepreneurship. You could seek advice from the business world, VC firms, Fuqua, entrepreneurs. Like the law school, the price is right, but many of the same issues. Also, some of the questions are truly legal and you need legal advice. And some of these issues are not in the knowledge set of the business world. I mean, this Bilski thing and technology transfer with universities, a lawyer will have a much better overview of technology transfer because they've dealt with Penn and they've dealt with MIT and they've dealt with, some of these law firms will know it better. But my ultimate goal here, and as much as I know this is not what you want to hear, is, yeah, you can talk to any one of us here. You really need a real lawyer. And you need it for a lot of reasons. Listen, this will cost a couple of hours of a partner's time. North Carolina partners will charge $400 or $500 an hour. I know you don't want to pay $800 to $1,000. But and the other thing though is this is your opportunity though to take a more casual search for a lawyer that I guarantee you at some point you're going to need with a much greater sense of urgency at a certain point. Someone's going to come to you, want to give you money, or you get a call from Duke, and the Duke people are going to say, "Listen, I hear that." And you're going, "Oh my gosh, now we got to run find somebody real fast." You need to build a relationship. If you're going into this, build a relationship. Back of the wrench, okay. Flow and Buzz researched a number of law firms. They interviewed 5. Ended up hiring a law firm to represent them in connection with general corporate advice. They selected this firm because it gave them the best feel for providing a good combination of legal and business guidance, had a good reputation for helping along startup companies. And by the way, I can't promise this. They had to figure out how to pay for this, scrape together 100 is my hypothetical. It is entirely possible that these firms, some of these firms will give you 2 hours of free advice. It wouldn't surprise me. It wouldn't surprise me because my experience has been, and again, I don't want to talk for these firms, I don't want to put this up on here because I don't want them to come to me and say, "Hey Bill, listen, you gave away our 2 hours worth of billings, reach into your pocket and reimburse us or something like that. But I think generally firms will talk to you on the initial call because they're in sales mode. They know that you're going out and talking to 5 firms, especially if you put it that way. Listen, we're going out, we're interviewing various law firms. We've got some pretty interesting technology. We have some great ideas. We can't tell you fully about what we have, but let's raise a couple of issues with you, just to see how you think about it. And you hear them, and they say, you raise the Duke issue. Well, I would think this, or I think that. All of a sudden, you're actually getting free advice during a call when they're in sales mode, and they're not going to bill you for this. So, but don't tell them I said that. But that's just the way it happens. Okay, and act coy, act like I'm a shopper. I don't have to deal with you. So then, to make this easy, and this is the biggest leap of faith in here. Because everyone, this person doesn't naturally exist. But all of a sudden, they were walking down the sidewalk and they stumbled on Mrs. Big, an angel investor. Ms. Big is well known in Triangle as someone who's interested in green technology. She hasn't really done much VC investing, but she's an electrical engineer by training, made a lot of money. She was a senior manager in a large automotive parts company. It's the dream. It's the dream angel investor for these guys, the dream investor. She proposes that you put a million in. I know it's a large amount. I just threw $1 million up there because it's not what you would see, but it makes the math easier when we're working through this math. In the company, in exchange for 40% of the company, that Flo and Buzz contribute their expertise, not money, in exchange for the remaining 60% of the company. Buzz and Flo cannot believe their ears. They ask Ms. Big to represent how to get this done as soon as possible. Ms. Big suggested the 3 of them incorporate the company in Delaware and divvy up the 100 shares of stock among them 40, 30, 30. Sounds simple? Should they do this deal? Does this sound like a simple deal? It sounds like a simple deal. It's pretty straightforward, right? A lot of deals get done just this way. It's a really nasty deal. Under Ms. Big's proposal, Flo and Buzz may immediately owe tax on $600,000 worth of income, and ordinary income at that. And in fact, there's an argument that they'll owe tax of $1.5 million worth of income. Boy, that sucks. That's bad. Why did that happen? Do you see what just happened? We've got, the IRS doesn't formally consider expertise to be a capital contribution into a firm. And so when it sees Ms. Big over here dropping $1 million into the firm for 40% interest, and then over here it sees these other 2 guys putting nothing in expertise, right? Putting nothing in, and now immediately, if that company were liquidated the very next second, what would happen is Ms. Big would only get $400,000 back, and the other 2 guys would get $600,000 back if it were immediately liquidated. So what the IRS is saying is, hey guys, this was actually constructive income for Flo and Buzz. And if they really want to get mean at the IRS, they're going to say, well, actually what happened was 40 shares were worth $1 million. And if 40 shares are worth $1 million, 60 shares are worth 1.5 times that much. So that's how. So you got to think about this stuff. It seemed pretty simple, and the sort of knee-jerk reaction that people have when they're putting together a company says, we'll just do it this way. Now, they could have avoided it. There's a typical way. If Buzz and Flo had formed this company first, and then Mrs. Big came along a lot later, This is what you call temporal differentiation in tax law. If she came along a lot later, you can make the argument, hey, when Buzz and Flo formed the company was worth nothing. And when Ms. Big made her investment, obviously it was worth a lot more, and Ms. Big was buying into that greater value company. Another way of dealing with it is through a technique called substantive differentiation. And you could have everyone pay $4 and $3 plus $3 for the common share. And so that everyone's buying the common share and everyone's actually putting in money. When I say dollars, I mean 300 pennies and 300 pennies and 400 pennies. And then Ms. Big takes her $1 million and spends it on preferred stock. Or spends it on debt. Spends it on something else that's worth different. So that's called substantive differentiation. She's buying a much more valuable piece of the pie. Because let's face it, if she buys debt, she gets paid off well before the other guys get paid off. All sorts of things start happening with substantive differentiation. So that's one approach. They got the lawyer involved, advisor involved, but if she got hurt, she actually is making a mistake for her. And this will, what's going to happen if she's well-intentioned, but once her advisor gets involved, her advisor is going to say, hey, you just gave up 6/10 of the company. If the company fails and needs to be liquidated. You put $1 million in there, in the next second, if it had to be liquidated, $600,000 goes out the side to Flo and Buzz. Furthermore, you set yourself up a situation for not getting your original capital back first. You're not going to get your original $1 million back first. You're going to, when stuff gets distributed, it's going to be distributed 40, 30, 30. What you want to do is you want to say that if there's any distribution out of the company, you get $1 million back first. And then it's the profits above $1 million that get spread out 40, 30, 30. But the first $1 million out of the company should go to you. She might want part of the corporation investment to be in debt, so the corporation gets a benefit from the interest rate deduction. That could be important for her. Although interest rate deduction in an early stage, no one really cares about because the company's not really making any income probably at this point. And she may want more than 40% of the stock for a number of reasons. Listen to that. The golden rule. My goal, my rule. And so, possible structures. Well, she could do something here, and the reason I put non-convertible on there is that once you start making that debt convertible, there's a real tendency to want to make it convertible. Without getting into the real details of that, that's going to give you some problems, but I don't need to complicate it any more than just simply say that's a flag if you get into this. But so you can have Ms. Big put in $500,000 on non-convertible debt. You can have her put in $490,000 on preferred stock, non-convertible again. She buys 60 shares of common stock for $6,000. Flo and Buzz scrape up $4,000 for the other stock, and that works. But the other thing that can happen here, keep in mind, this again is another reason to get on the patent stick. Ms. Big can put in, say, $250 for the debt, $250 for the preferred, and then $500 for the common stock. And then what Buzz and Flo could say, listen, as part of our capital contribution, rather than contributing expertise, we're contributing our patent. Our patent is worth money. And we think, for various reasons, you put something in the file, and you sort of substantiate why you think it's worth $500,000. So that's a way to do it. I mean, these are just two ways. There are a lot more. There are other issues. I'm finishing up here. Sorry, I'm going over. Type of company, LLC. Early on, it will be an LLC because it ends up passing through the tax benefits to everyone. All the losses get passed up to the owners. Whereas if you have a regular C corp, it will not pass up any tax benefits. It keeps the taxation, all those tax losses down in the corporation, so it's not tax transparent. In fact, you get double taxation because with a C corp, the corporation gets taxed, and then then if it dividends it up, it's going to be taxed again to you. So C Corp's a problem at this point. Generally, at the very early age, partnership, who wants all that liability? So LLC at the very early stage is going to be, unless somewhat venture capitalists, though, tend to prefer C Corps. I suspect, though, that we're getting to a world where VC firms, we can actually deal with some of the issues that they would have with LLCs. But for the most part right now, venture capitalist firms, when they come up and they find an LLC, that's fine, it's a great way to start up the company. They're probably going to require you, once they start putting in their round of money, to convert it into a regular C Corp. There are different reasons why they could do that. Again, it's part of it is, a lot of it becomes especially problematic if they have ERISA money, for instance, and they have unrelated business income tax. I mean, it's just, I don't need to get into those issues. Protect and nurture the IP above everything. Patent's key. The other thing is people won't believe it until they see it, so get your hardware. Make sure that you get hardware models and stuff like this. I mean, models and getting to the point of working models, one of the things that ends up happening is that people end up marketing prematurely. And they may sell their company or try to sell interest in their company before it's really ready. And so they take too high a premium to sell into a pipe dream, whereas they put just a little more time in developing their company. They're able to sell something more tangible, and the more tangible you can make it, the more money you can get for it. People still, even so, they're not going to give you a substantial amount of money until you have a team and a business plan. And quite frankly, the biggest reason that a lot of these things fail are teams, your management team, because you don't have that in place. The little things here, if you have a traditional idea, the team and the business plan are the most important. If you have a change the world idea, then that can assume a little greater importance. On advice, sorry. And finally, ending up on Ben Franklin. He gave us some great tips for the VC world. Genius without education is like silver in the mine. Always read, continue to educate, continue to learn about your product. Well done is better than well said. Do it. Don't talk about it. Do it. He's a fool that makes his doctor his heir. Don't get in bed with someone who wants to see you die. This happens more than you know. People get frozen out all the time. People will want to put money in your company, and if you don't work about, and I haven't spent anything on shareholder agreements and stuff like this, but this is where this will come up. People will want to take it over and inch you out. Work while it's called today, for not have to be hindered tomorrow. I guarantee that always happens to me. I thought I could fix this presentation today rather than yesterday. I decided to go out with people, but you can see I left a bad slide in there. So I should have, if I stayed here last night about 15 more minutes, I would have made sure that bad slide wasn't in there. I just quickly skipped over. So I should have done it last night. Necessity never made a good bargain. Don't try to sell your company when you really need the money. In fact, one of the best things you can do is tell people you don't need the money. And, watch the reaction. Because if they really like your idea, they're going to want to try to figure out how to give you the money. So, if you say, we're okay right now. We're just presenting things to you because we just want to give you an idea of where we're going. But, when we get ready to raise capital, I'm sure we'll come visit you for sure. We'll include you in the roadshow. Those things that hurt, instruct. Failure is important. Learning from your mistakes, that's really important. Glass, china, reputation are easily cracked and never mended well. Be very careful about how you hold yourself out to the world, because you are making a reputation, and do it carefully. Life with fools consists in drinking, with the wise men thinking. But then again, my favorite, beer is the proof that God loves us and wants us to be happy. So thank you guys very much. I really enjoyed talking to you.
so much, Professor Brown. That was great. Folks, if you are leaving, please do fill out those feedback forms before you leave and leave those with us. We do hope that most of you will stick around so we can do some, we're going to do 4 elevator pitches here, I believe. So why don't we go ahead and get on that. We're going to just so you guys know, instructions for these elevator pitches. So we're going to just have a few startup pitching. Each is going to get, I'm going to say 2 minutes. I won't be stopping you, but if you get to 3 minutes, I'll raise my hand, so just be watching me. Trying to go over that so people need to get out of here. And then if y'all in the audience please talk to the speakers afterwards, I'm sure they could use your help or feedback or whatever. We can get some fun better ideas. And I think we just have 4 ideas. Are you up first? Yes. All right.
Hi, I'm Andrew Simon. I'm a first year at Fuqua. I'm working with a company called General Nano. We are working on a commercialization of technology from the University of Cincinnati's Nanotechnology Lab. What the company's done is produce the longest carbon nanotubes in the world. So carbon nanotubes are cylindrical carbon molecules that are about 300 times stronger than steel and about a 1/20th of the weight. So not only have we produced the longest nanotubes in the world, but we've also patented the technology to take those nanotubes and spin them into usable thread. So we've patented technology in the United States, the EU, Singapore, China, Japan. We've got it all covered. We've received phase 1 and phase 2 funding from the Air Force in SBIR funding. And what that funding is trying to replace copper wire on the next generation of fighter jets. So copper wire is about 5,000 pounds of the weight of a fighter jet. Our technology has the same electrical capabilities, actually stronger electrical capabilities of copper wire, but about 250 pounds as opposed to 5,000 pounds. So imagine what a fighter jet could do with that less of weight. We've also had interest from General Electric, Honeywell, Lockheed, Northrop, slew of companies. So if you're interested in learning more and joining the company, there are a couple guys from our team that are here. Jonathan Lee right here, Danny and Christos in the back. So we're a team of Fuqua and Pratt students who are working on commercializing this technology. Any students interested, please send me an email or approach any of us after the event. Thank you.
Hello, my name is Evan McCormick. I'm a first year at Fuqua. We are working with a cardiovascular surgeon here at Duke who is developing a technology that is able to take blood, separate the cells, and then use those cells to coat a medical implant. He's primarily focused right now on cardiovascular disease, so they're looking at heart pumps. So they want to take your native blood cells, put them onto a device that when it goes into you, it'll prevent clotting, so the body won't reject the device. It's pretty early stage, but he has filed a provisional patent, and he recently was granted $1 million grant from the NIH. So what we're trying to do is primarily focus on how to get more funding, and the team that we have, a 5-person team within the first years. They're trying to identify how to get more funding, whether it's through grants or through additional JVs with other healthcare companies, and then develop the business plan for him. They have 5 other doctors working with him on this. So they've got the technical know-how, but they don't have the business know-how, and eventually we'll be needing some legal know-how as well. So if you have any interest, again, I'm Evan McCormick, and you can reach me at evanmccormick@duke.edu. Thank you. Just 2 more. We've got Shal Chowdhury and Joe Knight. Joe, go ahead. Why don't you go first?
So we're a little bit less formal. We're just going to give you a quick overview. So my name is Joe Knight. I'm a first-year Fuqua student. My background is in engineering. I'm going to tell you about 2 different projects I'm working on. One that I'm running that's on a medical device company. I won't give you too much details on it, but basically it's a device to treat urinary incontinence, which is a huge need. 50 million people in the world that have this condition, and over $8 billion a year in the U.S. alone that is spent to try to treat it. with over 300,000 women in the US that have tried and failed all current treatments that are available. So we have a device that is from Stanford University that I'm one of the inventors on the patent, and it basically is a series of valves. I won't get into the technical details. So that's the one side. So there's going to be some interesting things from a legal perspective as far as dealing with Stanford and going through their tech transfer office, as well as getting things set up for the company. The other company that's going forward is a different team, but it's based upon, this one might be a little bit more interesting if you're interested in some type of international law. This is based upon something that I started last year in October. I had the opportunity to go to Kenya, and so this is much more of a social venture. I went to Kenya and I taught the process of innovation, a process of innovation that I've learned the basic foundation of from Stanford, and I adapted it from being able to do healthcare needs, which is what they teach, to being able to use to solve any kind of need. And we had a 2-semester course, and what it ends up being now is that we're modularizing this curriculum so that we can put it on a flash drive or on a DVD, and then deploy it to different developing world countries to allow them to find and solve the biggest needs in their community. Because in the Western world, we oftentimes put money at the top and hope that it trickles down. And so what we want to do is inject the education at the bottom so that the people can actually solve their own needs. Who better to understand and solve the needs of their community than those people that are in those communities? So there will be some very interesting things. We're doing a little bit of market research now, so it's a matter of getting into there's going to be different legal aspects that we have to deal with in the different countries that we go into. So if you're interested in either of those, I'll be around, and just talk to me and let me know.
Your name and email address?
Yeah, my name is Joe, last name Knight with a K, and my email address, the easiest one is Joe, J-O-E, at docnight.com. So DOCKNIGHT.com. Joe at docnight.com. Thank you.
And before we have the last person up, I just want to mention that at the Duke Startup Challenge kickoff and match event, which will be next Thursday over at Fuqua, in addition to learning about the Startup Challenge, there are going to be plenty of pitches like this. So if you want to match with the team, that's a great venue for you to come. 7 o'clock Thursday, McClendon Auditorium at Fuqua. So last person, Shal Chowdhury.
My name is Shal Chowdhury. I'm a first year at Fuqua as well. I am coming from a finance background. I actually worked at Goldman for 6 years before coming out here. So my idea, actually Fred Koo, who's also in my team, he's here as well. So if I don't get to talk to you, he's there. I can talk to him. So our idea is to centralize vaccination records. Those of you who came to Fuqua or any of the schools, you realize how painful it is to gather your immunization records so you can give it to school. And that's not only in your grad school, it also happens in your high school, your undergrad, everywhere. So we're trying to create a central database so that vaccination records could be kept there forever. Our primary target is actually the schools. We want to manage the data for the schools so that schools don't have to employ people to check off your records. There is a lot more we can talk about that, but if you guys have any interest at all, we have a team of 7 people. I don't think we need any more, but if you're interested, you're in law school, or if you have a technology background, we can certainly use you. So anyway, my name is Shal Chowdhury again. You can look me up in Fuqua World. Or if there's
Spell your name for that?
first name is Shal, S-H-A-L, and last name is Chowdhury, C-H-O-W-D-H-U-R-Y. I know I spoke with a couple of you, when I came here first, so feel free to talk to either me or Fred. Thanks.